Sarah Marinan, England Volkers here. I want to do a quick overview because every August our purchase agreements in Minnesota change. And so this is just going to be like 5 minutes to tell you all the things in the purchase agreement. We're not going to go through details. This is just an overview so you know what things are in the purchase agreement. So we're going to start here with the purchase agreement having the date, the buyer's name, the earnest money amount, the street address of the property, as well as the legal address. This paragraph is a pretty big deal because it tells the buyer and seller all the things that the seller has to leave with the property. And then of course it gives us a line to add anything that maybe not was included in that list that was going to stay, like a washer and dryer. If there's something the seller is taking down, like if they're unbolting their grandmother's bathroom mirror, this is also the place where they can say that will be taken down before closing. Then we have the purchase price, how the property is getting paid for, cash, financing, assuming the seller's mortgage, contract for deed, very rare but an option. The closing date, that's the day that the buyer pays the seller for the property. The terms of mortgage financing, so unless somebody's paying cash, this section becomes very important. It talks about what the buyer has agreed to do for financing with the lender, and that if they can't get these terms, do they have the right to back out of the property? Do they keep their money? Do they forfeit their earnest money to the seller? What happens if the lender and the buyer drop the ball and don't stay on top of the financing to get everything done in time for the closing date listed above? Then who keeps the earnest money? Is that retained by the seller or refunded to the buyer? And under what circumstances? We'll talk about the rate lock. In a slow moving rate environment, it's not as important and we don't hear as much about it, but it's a very big deal if the rates are all over the board, or if the buyer's financing is not flexible, then we want to get those rate locks done right away. If this is a government insured loan, FHA, DVA, sometimes there are appraisal and inspection repair conditions affiliated with those kind of loans. We need to know who fixes things and who pays for those things to be fixed in order for the mortgage to go through. There's going to be lender processing fees and those things, particularly with some government loans. Who's going to pay that? Same thing with all of the buyer's costs. The buyer is going to have prepaid taxes, insurance, those things they need to fund, probably funding fees and lender fees if they are getting a mortgage and not paying cash. Sometimes buyers are a little cash poor and they really need the sellers to pay these things in order for them to close on the property. The sellers already have their own expenses and commissions to pay and everything else, but to get a deal together, traditionally in a buyer's market, the buyer will also try to get the seller to cover some of their expenses. In Minnesota, our disclosure law says, for your protection, get a home inspection. We've always encouraged buyers to hire an outside third party, unbiased, to take a look at the house. Somebody who is not related to the buyer or the seller that can just look at it and create a report and say, here is the condition of the house. Even brand new houses, those inspectors find things. That's their job. They want their buyers to feel like they were worth the money. So then we just go from there and find out who's responsible for fixing it, or if it even needs to be fixed. Maybe it's just an FYI for future repair. No intrusive testing. That means the sellers don't have to worry about the buyer's inspector like cutting open a wall to test for something like mold or insulation or whatever things they're looking for. All of this has to be done on a timeline, and usually in Minnesota it's about 7 to 10 days that the buyer has to get the professional inspector out there, look at the report, and negotiate that with the seller. If the buyer has a property to sell, then we have to discuss what the terms of that sale are and if it kills this purchase or not. Taxes and special assessments. Everybody who's ever owned a property knows that property taxes follow the property, and so when the buyer assumes that property, they assume taxes, but how are we going to prorate that and handle that? If there's any assessments, let's say the city streets have all been redone in front of the property and the local assessing authority added money called an assessment to the seller's tax bill. If the work just got done, is it the buyer's responsibility to pay that off because they're using the new road, or will that be the seller's responsibility? Title. Well, first of all, is there another purchase agreement that needs to be canceled around this property or from the buyer that has to happen before this deal can go through? And then title. So people wonder what title companies do. They research the history of the property and make sure that the owner is conveyed from one to the next, the ownership, and all of those documents are recorded, and that the mortgage gets recorded and everything is documented when the sale happens. As long as everything is smooth, one seller can pass to the buyer a warranty deed. But if it's, family member selling for somebody who passed away, or there's been a foreclosure, or there's a contract for deed or something else, then this is where that would be noted. Again, at the beginning, we talked about closing day being the day the buyer pays the seller for the house. That is usually in Minnesota the day that the buyer takes possession of the house, so they would get the keys immediately after closing. That is something we can also negotiate as well. There's a bunch of information in here about the titles and the surveys and mechanics liens and government notices and all kinds of disclosures that need to be made between the buyer and seller. And then, of course, some agreements that people guess. They say, oh, this room's about 10 by 12. Well, if the buyer is really, really picky about knowing that that room is 10 by 11 and a half, then it's on them to double check and make sure it satisfies their needs. It's not the seller who has to get this accurate to the inch for the buyer. Access. Buyer can access the property for surveys and inspections as agreed in this agreement, not just anytime willy-nilly. Risk of loss talks about what happens if we have a big storm or ice dams or those things, who pays for that and how the property gets fixed. Calendar days, business days, deciphers that. Talks about what happens when the earnest money is transferred. How does it get relayed to the seller or buyer or refunded? Default, all the statutes regarding default. Predatory offender information. Buyers have to look this up on their own, see who lives in the neighborhood they're buying. The seller has to provide a property disclosure, or buyer and seller have to agree to waiving that disclosure. If there's city water or private well water, if there's city sewer or a private well on the property, we need to disclose all of this and decide if there needs to be an addendum to have things inspected. Home warranties. Everybody has their own feelings on insurance and warranties, so that's also negotiable in here. If the mechanicals or those things are older, is there going to be a warranty on the house, and who's going to pay for that? Dual agency, that would be if the buyer and seller were using the same broker for the transaction. Closing costs, again, we talked about the seller and buyer have their own costs affiliated with this, and that effectively changes their cash outlay, and they should calculate that on their own. That is not on the buyer or seller's agents to know their finances. Settlement statement usually comes through from the title company. They need to make sure that they are reviewing those things before they go on and sign. Foreign investors, if you're not an American citizen, we'll look at that. This is a fully executed purchase agreement. Even with electronic signatures, once this is signed, this is binding. And the only way to change it is to have all parties agree to amend it, to change it. But if this didn't cover all the terms we wanted, knowing that this is said and done, we would go in and add some of these addendums. Like I mentioned earlier, if there is a well and septic, there is a contingency near the bottom here for that. And if it's a townhouse, there's going to be a contingency for that. If the house is, older than 1979, there can be a contingency for checking lead-based paint. So there's a lot of additional things here that can be negotiated by adding on to this purchase agreement. And then last but not least, until all parties sign, this is not a final agreement. So if there is something that needs to be changed here on 494, you would check this box and say, I can't sign this until some things are changed. And then when it goes back to the buyer, we can decide if we come to terms on that. Offers usually come on this format from the buyer to the seller. Very occasionally does the seller and their agent write the agreement first. So that's why I said usually if this $4.94 box is checked by the seller, they're saying I can't sign what you're offering without changes. And then lastly, there's an arbitration addendum or disclosure, that comes with every purchase agreement, and that's something everybody should read as well. Wire fraud is a big deal. There's a little disclosure on that here too. So a lot of stuff to think about, but when it comes your time to review a purchase agreement, the details will be very thoroughly reviewed. So I hope you're having a great day.